At this time, I'm going to introduce our moderator, Karin Ferriter. She is with our office here, and she's going to talk about, or with, all of our IP attache has-beens or futures. And it's a program here we have at USPTO where we go out into other countries. They focus in regions of the world, providing information on intellectual property, whether it be patents, trademarks, copyrights, or enforcement. They do a lot of work internationally, and they're going to tell you all about that and how it affects you and your business.
Seems like it's on now. Thank you. So welcome. Thank you very much for coming this afternoon and staying for the last panel. Hopefully we have saved the best for last. My name is Karin Ferriter. I'm the Deputy Chief Policy Officer of the Office of Policy and International Affairs. So I'm really happy to have three representatives of our office here today: Dominic Keating, Dorian Mazurkevich, and Elaine Wu. I've worked with all of them for a very long time, and they will represent our office very well. In our office, we have several main groups: the Intellectual Property Attaché program, which you'll be hearing about. We have 5 policy teams: patent, trademark, copyright, enforcement, and China policy team. So we have groups of attorneys within that. We also have the Global Intellectual Property Academy, and we have several other sections that are relevant to general policy making, such as the Office of the Chief Economist. So I'm very excited to have the opportunity to talk to you all, because our office offers some very important resources to SMEs, and we really want to make sure that you can make your invention a success. And if we can help you do that, we're very happy to do that. The main thing I really want you to understand and make sure everybody knows is getting a US patent is very important, but a US patent just protects you in the US. I don't want anybody leaving here today thinking you don't need other types of intellectual property protection. For example, if you're going to be having it manufactured in China, you probably should be looking at getting a patent in China as well. So please understand that there's no such thing as a worldwide patent. Filing through the Patent Cooperation Treaty helps you get patent applications filed worldwide, but there's no international patents. You have to get patents wherever you want protection for your inventions. So with that very brief introduction, I'm going to turn first to my team, who will give a general introduction of themselves, and then we'll have some questions.
Thank you, Karin. I'm Dom Keating. I wanted to just briefly introduce myself. I started with the agency more than 20 years ago. I started as a trademark examining attorney. I had a background, a master's degree in biotechnology and some research experience. I wanted to work as a patent examiner. There was a hiring freeze on at the time in patents, so I was able to find a job as a trademark examining attorney. Did that for a very short time, just over a year, until the hiring freeze was lifted, and then I applied to and got a job as a patent examiner. Wonderful job. Really enjoyed working in pharmaceuticals. It was heterocyclic organic chemistry, so pharmaceuticals, a little bit of biotechnology, and then after a few years of doing that, I had the opportunity to go work in the Office of Legislative and International Affairs as a patent attorney. Got to enjoy that. Eventually, our only IP attaché position at the time, which was based in Geneva, opened up, and I applied to that job and was selected. And I arrived in Geneva to start that job just a few months before a round of multilateral trade negotiations started at the WTO in Geneva. So it was a really exciting 2 years to be there. I had a lot of fun, and then I came back to USPTO headquarters to work in the Office of Policy and International Affairs, first for a few years as a patent attorney, and then we formally launched the IP attaché program, creating new positions around the world, and I was asked to go to New Delhi, India, to open our office there, which I did, and I stayed there for 4 years, serving as an IP attaché. Had a wonderful experience doing that, and then came back to headquarters, and shortly after that began directing the program. So I've had a wonderful experience here at USPTO. think it's a very professional agency, a great place to work, and I hope that you guys have great success in working with your patent examiners and other officials here at USPTO.
Thank you, Dom. Maybe we'll jump to Elaine.
Hi, I'm Elaine Wu, and I'm the Senior Counsel for China at the Office of Policy and International Affairs at the U.S. Patent and Trademark Office. I started out in private practice for a number of years in several large D.C. law firms and decided that I didn't want to work 24 hours a day, and so came to the Patent and Trademark Office and been here almost 20 years. I also did a little stint at the Office of the U.S. Trade Representative, so I have somewhat of a trade background and also a patent litigation background. And I'm the senior counsel for the group that deals with China. So I heard the tail end of the talk before, and there was a lot of interesting things that people were saying about manufacturing in China and doing work in China. And so we have a whole group dedicated to doing China work. I'll talk about that a little later. But it's an interesting time to be doing work with China these days. But we have a lot of expertise in the office, and I'm excited to talk to you about how we can help you all out for those of you who are interested in that market.
Thank you, Elaine. Dorian.
Good afternoon, everyone. My name is Dorian Mazurkevich. I'm an attorney advisor in the Office of Policy and International Affairs, working on the enforcement team. Professionally, my background in college was biology and chemistry, and I did some work in cell research and also in organic chemistry. And then following that, I went to law school and became a patent attorney in private practice. I then moved into doing IP litigation and also complex commercial litigation. During that time, I was also a volunteer arbitrator at the Philadelphia Municipal Court. I then received a fellowship to teach intellectual property law overseas, which pulled me into the international IP arena. From there, I joined the U.S. Patent and Trademark Office and then became their intellectual property attaché based out of the U.S. Embassy in Brazil, covering Latin America. And then since that time now, I've been part of the Office of Policy here working on enforcement issues.
Thank you. So as you can see, the people here today have a really deep experience in intellectual property, and now I'd like them to talk a little bit again about the different teams that we have and some of the resources that we have available to SMEs. Maybe we should again start with Dom.
Thanks, Karin. The IP Attaché program is a tremendous resource for small inventors and SMEs. About a third of the folks who contact us for assistance are SMEs, including small inventors. IP attachés are diplomats, the U.S. diplomats, but they're also senior intellectual property lawyers. The average number of years of experience as an IP lawyer is more than 15, so they're very useful resources, a lot of experience that can be brought to bear to help you all. And they're based in U.S. embassies and consulates around the world. And you can see on the screen the locations where we are, and I'll just talk you through it. We've got Laura Hamill in Rio de Janeiro, Brazil. She's covering Brazil, what we call Mercosur, and the Guianas. Think about the eastern side of South America. And then Ann Chedovitz in Lima, Peru, covering the western side of South America. And then if you move north to Mexico City, we have Cindy Henderson, who's an OPIA attorney who's just coming into the job. She's going to arrive later this month. And then when you hop over the Atlantic to Brussels, well, first starting with Geneva, we have Christine Schlegelmilch and Debbie Lashley Johnson, two very talented attorneys working on World Trade Organization issues and World Intellectual Property Organization issues. And then a little bit further north in Brussels, we have Susan Wilson. She covers all of the European Union, and that's a very important market for a lot of SMEs and small inventors. If you move a little further east, you've got Kiev, Ukraine, and that's a new office that Dorian is going to be opening in the coming weeks, and he's preparing to go out. He's been selected. He's served as an IP attaché for us in the past in Rio, and we have complete confidence that he's going to do a bang-up job in that new location. A little further to the east, we have Kuwait City. Pete Maraveri is our IP attaché there, covering all of the Middle East and North Africa. He's a patent attorney by background, and as I mentioned, all of our IP attachés are IP lawyers. And then moving further to the east in New Delhi, we have Shilpi Jha, who's our local IP specialist. And I should mention here that in addition to the 13 IP attaché positions we have in the program, we have 30 local hires, and among those, about a third of them are local IP lawyers. So each of the attachés has local IP lawyers to help them with the issues and to understand how the local IP system works, and to be an additional resource for you all. And then moving further to the east, in Bangkok, Thailand, we have Kinesi Sukapinda, who has a PhD in biotechnology. She's an attorney, a patent attorney. She covers all the ASEAN region. And then in China, we have 3 positions, Beijing, Guangzhou, and Shanghai. Duncan Wilson is in Beijing. Conrad Wang has served for 5 years for us in Guangzhou in the past. He's here at USPTO headquarters, but on October 3rd, he's going to be going back out to Guangzhou, and we hope that he'll stay for another 5 years because he's such a great resource. And we've selected a new IP attaché for Shanghai who hasn't been announced yet, but that'll be coming very soon. So those are the locations we're located. What work do we do? Well, we help to improve intellectual property systems for your benefit. This is done by directly advocating with host government officials. That means sitting down with them and explaining our perspectives on intellectual property, why policies, laws, and regulations should be changed to make the systems more effective for protecting and enforcing intellectual property rights. We also train government officials, and this includes patent examiners, trademark examiners, customs officials, judges, police, anyone who works on intellectual property. We train them to help them become more effective at what they do. And a third component of their work is we reach out to the public to help them to understand the importance of intellectual property, why it should be respected, why it should be protected, why it should be enforced, and that it creates gradual change within a country or region, and but it's been fruitful for us so far. And a fourth component of their work that's very important to you all is we directly assist U.S. stakeholders who come to us, and we have stakeholders, including small inventors, including SMEs, who come to us all the time asking for assistance. The attachés sometimes provide assistance that's simply explaining how to use the IP system locally. Here's how you would file your patent application. This is the correct point of contact in the among the customs authorities. This is how you work with the police to conduct a raid. This is what you do if you get into a legal dispute locally. These types of questions, this type of information can be extremely valuable. There are times when we see discrimination or some other problem that's systemic that affects our inventors and our SMEs. In those cases, the attachés will sometimes approach the host government and explain the problem, often not identifying the specific individuals having the problem in order to protect them, but identifying the issue as a bigger picture problem and trying to get assistance. And we've had many examples of success. In one example of when I was in New Delhi, we were getting ready, I was covering the entire region of South Asia, and we were getting ready for a TIFA, Trade and Investment Framework Agreement negotiation in Sri Lanka. And this negotiation is headed by the U.S. Trade Representative's Office, but they draw upon the other agencies for support. And I was one of the team, a part of the team. And I went down in advance and met with a number of U.S. stakeholders who are doing business there to find out what the problems were. And we heard from a number of businesses that the government, the Sri Lankan government, was using unlicensed software. So they were just pirating, using pirated software, not paying the U.S. right holders. So I prepared a paper on that, a position paper on that, gave it to the U.S. Trade Representative's Office. They cleared it, with the other agencies. When we entered into the TIFA negotiation, they asked me, as the IP attaché, to raise the issues and lead the negotiation on that particular topic. Ultimately, the Sri Lankan government, the Director General of the IP office, on behalf of the Sri Lankan government, agreed to do something about it. And a policy was passed. Well, after following up with that Director General, a policy was passed to prohibit the government use of unlicensed software, saving U.S. stakeholders potentially millions of dollars. That was just one small example. Probably others here would have other examples. But I think, once again, it's a very valuable resource. It's there for you. If you go to the USPTO website, you can go to the IP attaché pages, and you're looking at part of the IP attaché pages on the screen. They have, if you click on each of those certain squares on the map, you'll see a picture of the IP attaché, their contact information, and either biography if you want that. But you can reach out to them, send them an email, give them a call. I recommend sending them an email because of the differences in time zones. and they'd be happy to talk with you and help you to work through some of the challenges that you might be facing overseas. With that, I'll pass the floor.
Thank you, Dom. I think you've provided a very helpful overview of the IP Attaché program, where they're located, and some examples of how people can help. Elaine, would you mind talking a little bit more about your experience with the China IP Attachés and what the China team and the China Resource Center add to this opportunity?
So taking from what Dom has said, and he gave a really great introduction about the IP attachés, and I kind of want to give an example of how it actually works for us in China, and some examples of specific issues that we've had to deal with rights holders and how we've managed to, in part, solve some of the issues. So as Dom says, we do have 3 offices in China. And so presently we have 2 IP attachés with a person in Shanghai that will be going there very soon. And on the ground, we actually have a China team that has 9 lawyers here at the PTO. All of us have expertise in a specific area concerning China. So, for example, I work on pharmaceutical and patent-related issues. I have a colleague that is an expert on enforcement issues. I have another colleague that's an expert on trademark issues. So all of us have expertise in a specific intellectual property area. We also have a copyright attorney, also someone that is expert in trade secret areas. On the ground in China, our IP attachés often also have specific expertise. For example, Duncan Wilson, who is our IP attaché in Beijing, he's actually spent 7 years in China as a trademark attorney before he came to the PTO. So he has specific experience in China on trademarks. And he has several attorneys in his office that are Chinese-trained attorneys. Now, Duncan himself is fluent in Chinese. He speaks like a Chinese native. He is not. However, if you close your eyes and you don't see that he's a white guy, you'll think that he's a native speaker. He's really, really excellent. And so these attachés have other Chinese-trained attorneys that are obviously fluent in Chinese and also are Chinese-trained attorneys, so they know the Chinese intellectual property law very well. So we have lots of examples where we've worked. Typically what happens is, for example, if you're a small company, you have an issue in China, you can call us up. We'll talk to you and talk you through your problem. We cannot provide you legal advice, but we can often point you in the right direction of where you need to go. And then often what we do is we introduce you to the IP attaché in Shanghai or Guangzhou or Beijing, depending on where you have your problem or depending on what exactly you want to do. If you want to visit China, and often, of course, obviously it's a good idea for you to do so if you want to file for protection or you want to establish a business entity in China, then the IP attaché can work with you and can help you navigate the intellectual property environment in China to do so. The IP attaché in China also works with the Foreign Commercial Service within the Department of Commerce, and they also have people in the Foreign Commercial Service that actually can give you even more broad and general information about structuring a deal or finding someone with whom you may be able to form some sort of joint venture, or help you deal with the due diligence that is absolutely required in China if you want to have a business partner there. So our IP attachés work hand in hand with the Foreign Commercial Service. So it really is kind of a package deal. So it could really help a lot of you who do want to do business in China. I want to just give you just one specific example of something that we did help with a company. It is with a large shoe company, shoe manufacturer. One of the issues in China is what we call local protectionism, and that is that often at a local level, the courts and administrative enforcement system sometimes is biased towards local companies, particularly champion companies. And so in this example, when we found that there were procedural irregularities in the court system, we actually had one of our IP attachés and one of the Chinese-trained attorneys sit in the hearing. This is a trademark infringement action, and we had the person sit in the hearing. just to monitor to make sure that there would be no other procedural abnormalities that the court would be engaged in. And as a result of someone sitting in and just basically making sure that all the procedures were followed, it actually helped with the outcome. So this is kind of an example of something that can be done and has been done with a lot of rights holders who've had issues with those kinds of things, those kind of abnormalities or local protectionism issues, which is really, really common in China. So that's kind of an example. So we really work in hand in glove with IP attaches on the ground. They are our ears and eyes on the ground. They do have the most updated information, often even more current than what we have about changes, legal changes, and so on. And also they have lots of very strong connections with the patent and trademark and copyright offices in China. And so that is also often very useful, certainly for us as we advocate for legal change with these offices, but also particularly for US companies that are interested or need to talk to the patent office because of some concerns that they have with their invention. So this is just a quick example.
Thank you, Elaine. If it could always be so simple, just by sitting next to someone, we help with their outcome. But that was a great example and something that we're happy to do. Of course, they provide much more sophisticated assistance as well. Not legal advice, but still significant help, especially just pointing to the resources. You know, those conversations really help us. We get a better understanding as to what's really happening, and we can make sure that when we have the opportunity to talk to the foreign governments, especially when we hear the same story again and again, and we do tend to hear the same story sometimes, we can say, no, actually, well, your procedure says X. We're hearing from many different stakeholders that what's happening on the ground is Y. What can we do to change that? Because that's not what's, say, published in your website. That's not our expectation for what would happen in that process. And we can help make change. And if we can't help make change, then we can call it out in the appropriate document to try to move slowly toward change. Dorian, maybe now you could talk more about the enforcement team in OPIA and how the enforcement team also works not just with the USPTO, but all of the other government resources. I know this is tall order, but these are just the IP attaches that we have around the world to help. Dorian, you have a huge network of other officials that would be very helpful as you begin your journey toward a very successful business.
So I know that most of the conference here has been focused about IP protection. How do you secure protection for your invention or for your idea? When you look at the... can you hear me now? Yes? No. So I know the focus of the conference so far has been about securing your intellectual property rights. A patent for an idea or some sort of design. When you look at the intellectual property universe, I guess the first part would be securing protection for the idea. But the second part of that equation would be how to enforce that protection once you've already gotten the patent or the trademark. And so as a member of the enforcement team, what my office works on is making sure that once those rights are acquired by the inventor, to make sure that they're protected, whether it's civilly or criminally through the court systems. Now, when we look at intellectual property, there is, of course, patents, trademarks, copyrights, trade secrets as well. And so in our office, what we do is we work both domestically and internationally on seeing what we can do to assist US entities in enforcing their rights. Now, earlier on, Karin had mentioned that, I guess the one important concept is that IP rights are territorial. So therefore, any right you have in the US does not have enforcement or protection in a foreign country. I think a second part of that equation would also be that IP rights are private rights. So to the extent that there is an infringement of that right, it really falls upon the rights holder to seek some sort of protection within the court system. What we have been able to do is try to help assist the companies or private individuals in securing that enforcement. And so we work domestically through various other government agencies. We have a cooperation with the National Association of Attorney Generals. We also work closely with a lot of state police officials and also with the Federal Judicial Center on training and capacity building to make sure that they are aware of the challenges involved in piracy and counterfeiting and what sort of support that we can give them here from the U.S. Patent and Trademark Office. Another thing we do is we provide guidance to U.S. inventors and also small business owners, and we do that one through the hotline that we've established, which is 1-866-999-HALT. It's called the Stop Fakes Hotline. Again, it's 1-866-999-HALT, and that is a hotline that's staffed by myself and 10 or 12 other attorneys. And you'll get a chance to talk to us. And although we are attorneys, we can't be providing legal advice, but we can give you some guidance on what sort of options there could be and the kind of landscape you're facing with regards to intellectual property enforcement challenges. We also have a website that's been set up, which is www.stopfakes.gov. And that provides a lot of different toolkits, both domestically and in foreign countries, on how the intellectual property protection and enforcement system works in those countries. So I encourage you to check out those resources. Again, the website is www.stopfakes.gov. Now, in addition to our domestic work, we also work internationally, providing some support to the U.S. Trade Representative on trade policy issues. What many of you might not be aware of is that when you hear about free trade agreements being negotiated in the news, very often there are strong intellectual property protection and enforcement provisions that the U.S. looks to negotiate. And they look to ensure to maximize access and also to maximize the protection and enforcement of U.S. intellectual property right owners that look to enter into foreign markets, that look to kind of access larger markets for their consumer goods. So at the USPTO, what we also do in the Office of Policy and International Affairs is provide support on those negotiations, going over the provisions in those agreements to make sure that they maximize the protection for the U.S. consumers. In addition, the other work that we do is provide support here to the IP Attaché program, which Dom had mentioned, and also work on training capacity building for those foreign law enforcement officials. Now, when you're looking at the issue of intellectual property enforcement, it spans a wide gamut of areas. It would be piracy, counterfeiting, and also now, which is a more troubling area, would be trade secret protection. I know earlier in some of the conference speakers had mentioned that instead of seeking for patent protection, many of them instead keep their information proprietary as trade secret protection. And so an area that we've been getting more engaged on in this is this sphere, and I will just make a plug for a conference we're going to be holding next Wednesday here at the U.S. Patent and Trademark Office called Leveraging Trade Secret Protection. And that's going to be focused on criminal enforcement of trade secrets. We're going to have speakers from the FBI, from different Department of Justice branches to discuss what are the best strategies for protecting trade secrets and what sort of support the U.S. Department of Justice has been providing on protecting trade secrets which are threatened both internationally and perhaps here domestically through some sort of misappropriation. So that's just a kind of thumbnail sketch of the kind of work that we do here at OPIA and the enforcement team.
Thank you, Dorian. And actually, I think I might have calendared it for Thursday. It's the 19th, right? Whatever day of the week that is next week. It's on the 19th. And so that trade secret program should be excellent. As Dorian said, it will be webcast. So even if you're not in DC, you can watch it anywhere online. And moreover, even if you already have plans for that day, you will be able to watch it anytime. We'll keep it available on our website for a while. I don't know how long, at least a year. That's usually our plan. So now you should have a pretty good understanding of the USPTO resources that are available to you should you intend to take your invention or your business globally. We did want to have some time for some questions. I saw the prior panel was really getting some great questions. So okay, is someone bringing a microphone around? Thank you. And then there's another question here for next. Thank you.
I'm just a small inventor. I have a number of patents. And the original ones, I just worried about US. I really hadn't gotten into the PCT business. And then on the more recent ones that do have more global potential, I get into the PCT. So I'd done the provisional, then the PCT. I'm sort of giving an example now because this will be beneficial to them and give you some insight into what I've gone through. And so I did the provisional, and then I did the PCT. Well, of course, now you've got more time. And like anything, you sort of go through and you realize as you're developing a product that things are not exactly the way you want. You improve them. So now I get to the point where I've got to file with the PCT, but I now have new figures, I have new designs, I'm now stuck on the old provisional. So what happened is I didn't realize you couldn't do a continuation in part with all these other countries, although they did send a letter back telling me I could have done it in Zimbabwe and Luxembourg. So anyway, and some of you may not understand it, but the point is when you file these things like a PCT, it damn well better be close to what you want in that utility patent, because then when you seek the international patents, you're stuck with it, right? Or am I wrong? See, so what I'm hoping is, what I'm saying is the truth about what the experience was, because essentially I didn't really know it. And the guy that was doing it had done a couple PCTs, and he really wasn't himself that experienced in going in it. And so the first question is, one, these are issues that are very important, but then the other is, where would I have gone to even find that out in the first place?
Okay,
Thank
so
you.
that's a very good question, because we're just talking here about the Office of Policy and International Affairs and what we can do to help you getting international protection. But in addition to all of the resources that we provide, we have a Patent Assistance Center, we have a Trademark Assistance Center, we have a Pro Se Art Unit. The USPTO has a huge array of resources to try to help you. But of course, I would, as a former patent examiner, strongly encourage you to hire a patent attorney, hopefully somebody who's, what we say, prosecuted, but filed a bunch of patent applications so that they really know what they're doing. We wouldn't want you to hire somebody who thinks that you can file a continuation in part PCT application. That makes no sense. So we want you to make sure that you're getting the appropriate kind of protection. It would be sad if they filed for a design patent when the invention was really more a utility. So the USPTO has great resources for that. That's not necessarily what we do, but we would connect you with those people should you call with a basic patent question. I understand right now there's quite a few people who aren't here because they're taking advantage of the kind of assistance that the Patent and Trademark offers. We have patent examiners who, and supervisory patent examiners and staff whose whole job is to provide that kind of technical assistance. So please avail yourself of it and ask questions to make sure that you get a clear answer because you don't want to start off your career in intellectual property on a misconception.
And Karin, can I just also mention, I didn't mention that earlier, I do also want to put a plug for our China IP roadshows, and this is focused on China, of course, but we do have China IP roadshows as part of the work that we do in our Office of Policy and International Affairs as part of the China team. And so we have gone to 27 cities in the country, ranging from New York City to Boise, Idaho. I was Boise, Idaho last winter. It's a fabulous place, by the way. It's really nice. Anyway, so I just want to let you know, for those of you who are particularly interested in China, we do have IP roadshows that we do in all these cities, and we spend a day. They are free. You just kind of have to get to Boise or wherever. We actually did one recently in Baltimore. We're going to do one in Princeton. But there are roadshows that are all over the country that really focus on China, specifically on China. And there are attorneys. We have actually attorneys there that are expert in filing in China. And so they're going to know a lot about what you can do and can't do. And so I just want to put a plug on that. And I noticed that Karen's put our website, the China Roadshow website page on our website. I invite you to look at that. And we have actually several roadshows coming up. And if you look at that now, then you'll see some of the roadshows that are coming up.
Thank you.
Hi, my question's for Dorian. Are U.S. patents enforceable against imports? Basically, are my personal rights protected from imports?
So with regards to protection of your intellectual property rights coming in from overseas, trademarks and copyrights are protected at the border by U.S. Customs, by Customs and Border Protection. With patents, however, in order to have those seized, you would have to file an action with the International Trade Commission. It's somewhat like a mini litigation process, and you would file what's called a 337 action with the ITC. And the ITC specifically provides jurisdiction over unfair competition regarding importation. So there isn't any protection through U.S. Customs, but what happened is you get a limited or an extensive order from the ITC upon the determination that there is potential infringement. So it's somewhat like a mini trial regarding whether there's trademark or whether there's patent infringement.
Thank you.
Thank you. So I have a question. So is there any advantage to filing a PCT first or a U.S. Patent first? Can you comment a little bit more on that?
I can give you a general response. So you can file a U.S. patent application and get it examined, or you could file a patent cooperation treaty application, which would initially have a search report and then a preliminary examination report, and then you could decide where you wanted to enter the national stage. The advantage to filing the U.S. application first is you would tend to get a quicker examination and perhaps a quicker patent. The advantage to filing the patent cooperation treaty application is that you would have more time to decide what you want to do, and you kind of have that stepwise approach where you would see the search report and know better whether or not you would eventually get a patent. So you can do it both ways. There are advantages and disadvantages to each approach. I think that in addition to the China Roadshow, our patent cooperation treaty group goes around the U.S. and does some basic education on the patent cooperation treaty. They would go into more detail to talk about the advantages and disadvantages of the two different approaches. But in general, people choose the PCT route because it gives them more time to decide whether or not to invest in filing applications in foreign countries. People choose the U.S. first approach because they want a speedier determination as to whether or not they're going to get a U.S. patent.
Is it possible that you could provide one of your China roadshow online that for people that they do not have or opportunity to be in one of those, they can see it at their time, because that is important for independent media.
Yeah, right. So we have not yet put it on, online yet, and partially it's because we have to get all the speakers to agree to have the broadcast online. So in addition to our roadshows, what we do is we actually have webinars as well. We have had webinars on how to file, for example, utility model patents in China. We are doing a webinar pretty soon, coming up in probably a few months, on design patents in China. We have had webinars on enforcing your rights using the administrative enforcement system in China. China has several ways to enforce your rights. One of them is called the administrative enforcement system, which is a less costly way of enforcing your IP rights in China, the most commonly used way. And so, and we also have also a webinar coming up on trademark protection issues and filing trademark issues, because there's a new law that's coming out, a new trademark law. So that is probably an easier way for a lot of people who aren't able to go to these cities. These webinars are just an hour or an hour and a half, and you can just get on, of course, obviously from your computer. And we do feature speakers. We actually have had speakers that have been beamed in from China. These are attorneys and experts in the area. So that is an alternative. And if you look at our website, we'll kind of advertise that information about some of our upcoming webinars. Right now, we have several upcoming roadshows, but we don't have yet an upcoming webinar, but our next one is probably going to be about design patents. So I would just, get on our web. In fact, the site that you have here, if you go on the upcoming events, you'll see in an upcoming events the ones that we will have upcoming.
Thank you, Elaine. So in addition to those webinars on the USPTO website, there are a number of distance learning courses. I think we're constantly seeking to improve those resources and also working to keep them up to date. So I would say if you don't see the type of material that you're looking for, please let us know and stay tuned, because that's something that we're continuously striving to offer, because not everyone has the time and resources to travel to where we happen to be providing the training. Are there other questions?
Yes, I have a question. So I've been tracking some of these larger companies like Louis Vuitton, Chanel, Gucci, where a lot of foreign companies or organizations are making their knockoff products and sell them overseas or here in the U.S. So when someone mentioned up there about the 337 action, I'm trying to figure out, how does that protect me, or does it block the company who's making these dupes or fake products that would be a replica of mine? Does it stop them from advertising? Does it stop them from shipping over here to the U.S.? What does that do as far as that mini trial? What does it stop them from doing?
Thank you. Dorian, want to continue?
Sure. Now, with regards to 337 actions, and maybe I'll just make a little more broader comments, because 337 actions are generally for patents that a rights holder might have. If you have a trademark or a copyright, those can be enforced by CBP, by Customs Border Protection at the border. And in order to get that sort of protection, one should take their trademark, which they already have registered with the USPTO, and then record it with US Customs. To record it with US Customs, you can do that online. The fee is $190, and it can be found at iprr.cbp.gov. So it's intellectual property rights recordation.cbp.gov. And once that trademark is recorded with US Customs, then they will be on the lookout to see if anything infringing your trademark comes across, and then it will be seized. Now, with regards to patents, US Customs doesn't have the expertise to make that assessment on whether two products infringe each other regarding the patent protection, because of the nuances and the kind of the particularity regarding novelty and other elements. So therefore, the US has established a system with the International Trade Commission whereby, as a rights holder of a patent, you can apply for an exclusion order. And in those instances, you would present what your patent is and also what the other patent is that you're looking to exclude, or sorry, the other product that you're trying to exclude at the border looks like. And if it's a particular product that you're looking to get excluded, you would explain how in the litigation process with it before the ITC on the similarities and how there is an infringement. In that instance, if it's a specific product, then the commission will issue a limited exclusion order. And that limited exclusion order then gives authority for US Customs to stop products that infringe that product at the border regarding patent rights. Also, the ITC can issue a general exclusion order, which is more broad, to give even broader protection regarding your patent rights. So there are two different systems. One is regarding trademarks and copyrights, which is more streamlined, and then a more nuanced program with the ITC regarding patent protection at the border.
Thank you. Are there other questions? Yep, thank you.
I've just got a quick question here. I heard you guys talk about the Chinese attaché office in there, and I'm trying to understand what the benefits are of working with them locally as compared to going through the PCT. Can you elaborate just a little more in depth about what the benefit would be of working locally with your people as opposed to going through the PCT? The reason why I say this, I have extensive training with WIPO, and they have advanced systems for translation of documents and other things, and I'm just trying to understand what benefits you could potentially provide that might be superior to their services.
Okay, just to make sure I really understand the question, what's the advantage to filing a U.S. patent application versus a patent cooperation treaty application, given the PCT application is more readily translated?
I guess if you have a local attaché office there, I would be working with them, right?
Okay.
So that it would be filed locally in that country, right?
Yeah.
So maybe I'll take this one if my mic is working. The attaché doesn't really, I mean, if you're interested in filing for patent protection in China, you can either file through the PCT if you're seeking to protect through a broad group of countries. If you wanted to protect just in China, you would file through CNIPA or the Chinese Intellectual Property Office. The attaché is there as an additional resource, so if you have questions about how the process works, how the Chinese laws work, you can ask the attaché. But really, you would be filing your application not with the attaché, but with the Chinese office or through the PCT system. But think of the IP attaché as an additional resource to you who can do different things. They can provide information, or they can provide other assistance, sometimes helping you to develop a strategy, sometimes helping you to maybe to find the right authorities, to contact if there's a problem. But they're not the ones who are going to file your patent application, and they're not the ones who are going to represent you legally. You'd have to hire an IP lawyer to do that. Is that clear? Okay, thank you. And if I may make one more comment, we've heard Elaine made a very helpful presentation about the role of the China team, and Dorian explained very helpfully what the enforcement team does, and just to tie it all together within OPIA, and Karin explained what OPIA does, but we have a patent team, a trademark team, copyright, enforcement, and then we have, and all those substantive teams also are organized into regional teams, and the regional teams work with the attachés. So when you work with the team, you can work with the attaché, and if you work with the attaché, you can work with the team, but ultimately it's more resources for you. Okay. Thank you.
And I did want to just make sure that before anyone files in a foreign country, if for some reason they're deciding not to file in the US, you do need to get a foreign filing license before you file in that foreign country. Otherwise, if you do subsequently try to get a US patent, you will find that patent to be unenforceable. So please, when you file a US application, automatically as part of that, you will be considered for a foreign filing license. But if you choose to go directly into China and bypass filing in the US, you have to come to the US Patent and Trademark Office first and request a foreign filing license. So just to make sure that everyone is aware of that. I'm a little bit worried that we're running low on time. Do we?
Yeah, we have time for one more question over here.
Okay, thank you.
Thank you, Chair.
Sorry, I missed most of the presentation because it's like conflict with 101 session. So I want, hopefully this is a good question. How about I? So I just wonder, filing patent in each individual jurisdiction, US, China, Europe, I think it will help you protect selling in that market, manufacturing in that market. Does that, in terms of supply chain, does that go impact upstream or downstream? I mean, in terms of the supply chain? In that particular market, I guess.
At the very beginning, and perhaps you did mention that, what I was trying to make sure everybody understands, and I'm glad we're kind of beginning and ending at the same point, is a U.S. patent protects you in the U.S., a Chinese patent protects you in China. If you're going to be in both markets, you need to have protection in both places. Similarly, trademark protection, you want to make sure you're getting because these rights are territorial, you need to make sure you're getting the rights in any territory where you need to be protected. So if your supply chain is jumping around to other countries, if it's going to India, Indonesia, seek to see what the appropriate protection is. You may need different types of protection. You may need a method of manufacturing patent in one country and a different type of patent or coverage in another country. Does someone want to round that answer out?
Yeah.
All right. Well, I'd like to thank our panel. Thank you for coming today. We appreciate your time. At this time, we are closing out the session for the day. The booths will remain open until 6 o'clock if you wanted to see anybody at one of the booths before you go. Please remember to return your surveys on your way out, and remember to sign in the morning when you return. Thank you, everyone. That was funny.